What's the difference between a preliminary hearing and a grand jury hearing? Fuel me once here, driving instructor of the world. Both are options to indict someone, but it's the prosecution that chooses which one they'll seek to do it through. Now, the standard to indict for each one is probable cause. See my last video. So why would the prosecution choose one over the other? Let's talk about the differences and see. By the way, the indictment for each is called a true bill. Grand jury hearings are private. There's no judge there, only a grand jury, a set of citizens that are called to serve for a few months in each state and also at the federal level. They can ask questions during the hearing, and they're the ones that determine by only a simple majority whether the case gets a true bill. They're often seen as rubber stamps because the standard is so low. One reason to use them is that the prosecution is the only one that presents a case. Sometimes a defendant won't even be notified or doesn't even know they're being accused. So the prosecution can go forward in secret without revealing any of their strategy, any of their evidence, except to the grand jury. Again, all those proceedings are private. If they don't come back with the result they want, they can actually bring up different charges, new charges, and proceed again with another grand jury. They can avoid potential criticism of their case either way. Prosecution can also work out or develop the strategies they want to pursue, seeing how it works with different kinds of juries, and then they can have a better idea of what kind of jurors they'll want to pick in the actual trial. Different states and the federal government have different rules. There's 12 to 23 members of a grand jury at one time. They have a lot of power to compel people to testify, and again, they do this behind closed doors. Preliminary hearings are before a judge, not a jury, and both the prosecution and the defense can present their case. They don't have to present all of it, just enough to try to get that true bill or try to defeat that true bill indictment. Here, each side can work out the strategies they have, the story they want to tell, and see whether a judge will rule in favor of each. They can also cross-examine each other's witnesses and, try to poke holes in each other's evidence. Again, the standard is only probable cause, so most often a preliminary hearing goes forward. But here's a chance to sway public opinion because preliminary hearings are public. They also allow evidence that would never be allowed in court, such as hearsay. Objection, hearsay. If you have any more questions, let me know.